Advocacy Days. Today is our kickoff, and we have two panels. The first that we're going to start with this morning is of Planned Lifetime Assistance Network, or PLAN, of Massachusetts and Rhode Island. And we have Attorney Poole, who is going to share everything about all trust options, as well as ABLE accounts. And then at the end, she's going to do a question and answer. We're so lucky to have Attorney Poole. She was actually a estate planning attorney for 10 years. So she has a lot of experience with this, and we're going to get a lot of information from her today. We ask that you use the question and answer feature that should be, you should easily have access to that at the bottom. Just anytime you can ask the questions. However, we will not be going through them until the end of Attorney Poole's presentation. So around 11 o'clock, we'll do a question and answer portion. So with that, I turn it over to Attorney Poole. Thank you.
Great, thank you very much. Bear with me here. I'm just going to pull the presentation up and share it. Always fun to see if we can do that. Right, here we go. I'm going to assume that everybody can see that unless you mention otherwise. Is it all okay? Okay, great. Let me change the display setting here. There we go. Okay, I think we're all set there. Let me know if we're not. All right, so thank you so much for joining me today. I'm so happy to be here to speak with you at the NAMI Mass Advocacy Day. A little bit, and as Jacqueline already mentioned, we'll do questions at the end. This should be about 45 minutes to an hour or so. And let me just check the chat here to make sure that, okay, there we go, that we got that okay. Okay, great. Thank you very much, Sophia. That everything looks good. Always nice to see. All right. So a little bit about me, and what I'm going to be talking about today is I'm going to be discussing planning options for you and your family with regards to special needs trusts. So here we go. Before I get started and diving into that material, let's spend a little bit of time on disclaimer, but also some terminology that I want to share with you. So first of all, keep in mind that this is for informational purposes only, and that it's really a great idea that we encourage you to work with an estate planning attorney, a special needs attorney, a person, an attorney who can really best advise you because they best understand your specific situation. So we strongly encourage people to work with estate planning or special needs attorneys. And in fact, we have some really great relationships with numerous estate planning and elder law and special needs attorneys within Massachusetts and Rhode Island and actually throughout the country. So also keep in mind that this is a recorded meeting or webinar, and that if you want to share information and your questions, that you may want to keep in mind that it's public and you may not want to share private information regarding that. Okay, so as I mentioned, let's talk a little bit about terminology that you're going to hear me use for the rest of the presentation. So first off is the idea of a trust. A trust in general is an entity that you create by signing a piece of paper. That's essentially a trust. And a special needs trust is a special type of trust that you will also hear me say interchangeably, a supplemental needs trust. Now, there's some folks who use supplemental needs trust for one type of trust, and other people use special needs trust for other types of trusts. For today's presentation, I really use special needs trust and supplemental needs trust interchangeably. What is a trust beyond this legal piece of paper that you've created? So in the document, you determine who is going to be in certain positions. So in a trust, you have somebody who's called the grantor. The grantor is the creator of the trust, and typically they're often the funder the person who's putting money into this entity, into this trust. You also have the person who's the trustee. The trustee is really the manager of the assets held in the trust. Then you also have the third role of a trust, which is the beneficiary. For our purposes, the beneficiary is really going to be the individual with disabilities with regards to special needs and supplemental needs trusts. So those are the three main roles of a trust or a special needs trust. Some other language that you'll hear me use is government benefits or public benefits. Again, I'm going to use that interchangeably. When I say that, I'm really talking about things like SSI, SSDI, Medicaid, housing vouchers, things along the SNAP. So those kind of public benefits, that's what I'm talking about when I say government benefits or public benefits. All right. So a little bit about PLAN before we jump into types of trusts. PLAN is a nonprofit organization that serves as trustee of special needs trust specifically. We have been serving individuals with disabilities for over 50 years. And what this allows us to do is that it allows us to hold funds in this trust while somebody is simultaneously on public benefit. So that's one of the game changers of a special needs or supplemental needs trust. Somebody can be on public benefits while also have funds in a special needs trust that can supplement the public benefits that they receive. So that's really the lens that we are oftentimes looking through when we have a trust that is holding funds for the benefit of a beneficiary. So because we're serving as trustee, we have a responsibility to make sure any sort of money that goes out for the benefit of the beneficiary is not going to endanger or jeopardize those public benefits that they may already be receiving or could be eligible for. It's also one of the things that we must do is to assist with maintaining quality of life. So the folks within our organization who help to achieve those goals for each beneficiary is that we have a licensed social worker, and that is a person who's called a service coordinator. And that service coordinator it's a unique aspect of PLAN. And they're typically meeting with the beneficiary's family or friends, other care providers, and really working together to figure out the needs and wants of the beneficiary, and then working within our organization, our trust officer, to make sure that meeting those needs and wants will not endanger that beneficiary's benefits, public benefits. So currently we have over 855 beneficiaries, and we have assets under management of $89 million. Again, we have our service coordinators who are licensed social workers who are guiding the beneficiaries. Let's see. And then we are also mentioned in the POMs, which I'll talk about in a little bit more detail in a second. So our mission is to serve people with all types of disabilities, whether that's due to illness, injury, or age, by helping them to preserve their assets, again, by holding them in this special needs trust, to protect their assets to public benefits, and to live well. So a few things that we're going to go through today is you're going to understand the purpose of special needs trusts, the types of special needs trusts that are out there, the trustee responsibilities and other considerations to keep in mind, how you would actually establish a trust with PLAN if you chose to go in that direction, and also ABLE accounts, because ABLE accounts are a tool that became available for use for individuals with disabilities about a little over a decade ago, and they are a great companion to special needs trusts. Excuse me, I have a little bit of a illness here, so bear with me if you hear me coughing. So where did special needs trusts come from? The OBRA 93 allowed for the establishment of special needs trusts. And again, this is where it created the ability for an individual with disabilities to benefit from funds held in the special needs trust while simultaneously maintaining or being able to receive government or public benefits. Again, such as SSI, SSDI, and Medicaid. The guidelines for the administration of special needs trusts are found in the POMS. That's the program's operational manual system, which is maintained by Social Security. So what are POMS? POMS are essentially sub-regulatory guidance from the Social Security Administration. That is really where it's the go-to resource for caseworkers, administrative law judges, and a number of other public benefit programs really piggyback off of the POMS or the SSA rules. So if you think about it, SSI is really opens the door to many other public benefits, and so it's really the foundation, which is why it's always good to go back to the POMS, which is discussing essentially how a person's public benefits may or may not be used. And then if there's other sources of funds that could reduce or eliminate a person's public benefits. So it's very nicely. Plan does have a shout out in the POMS because we've been around for a little while. It is a great example of a Medicaid pool trust. So what's a special needs trust? Let's dive into that a little bit more. We already talked about it. Let's go over it a little bit more. So it's essentially a legal document, typically a multi-page piece of paper that you sign, and once you sign that document, you have created the trust. And then what you can do is you can fund the trust. You can fund the trust at the time you create it by putting money into an account in the name of the trust, or you can create the trust and it sits there as an empty shell until money goes into it at a later time. That is oftentimes called, at least with us, a future funded trust. And we'll talk about that in a little bit more detail and what kind of scenario that would come into play in the future here. So assets held by the trust are not considered a resource when qualifying for any means-tested government benefits. So for example, Medicaid and Supplemental Security Income, SSI, where you can only have a certain amount of assets, and if you're over assets, then you would not be eligible for those benefits. So one strategy that a lot of people have is that if they're going to be over asset, they can put some of the funds, some of those assets into a supplemental needs or special needs trust and still qualify for public benefits or maintain their eligibility for public benefits. The supplemental needs trust allows, again, that person to supplement their public benefits and not replace them. But it allows the funds in the supplemental needs or special needs trust to be available to cover those expenses that public benefits do not cover, which can be a lot of things, and we can talk about that a little bit later on. Okay, we'll just move on to the next slide here. Okay, so why is a special needs trust helpful? It does allow for peace of mind. It, especially for the future. It can also allows the beneficiary again to preserve their public benefits, supplement their needs, and have the means to improve their quality of life. So there's a lot of things that public benefits do not pay for, right? So if you need to get over-the-counter medication, if you need clothing, if you need furniture, things along those lines, that's not necessarily covered by public benefits, but they're still necessities. So that can be quality of life, as can traveling. So if a beneficiary, an individual with disabilities, would like to go on a particular vacation or trip, and maybe they need a companion to go with them, then the funds in a special needs or supplemental needs trust can be utilized because it's based on their quality of life. It's allowing them to have a quality of life over and above what is covered by those public benefits. It can improve family relationships. And then again, it goes to covering costs that are not covered by public benefits. Who can benefit from a special needs trust? So a couple of examples: an individual with a disability who wants to maintain or their eligibility for public benefits. If you have a family member who's concerned about the well-being of a disabled person, but they really cannot or should not take on the responsibility of assisting with the financial management of that individual with disabilities, then a special needs trust, especially when there's a professional trustee involved and not a family member, is a really good tool, right? It allows for maintaining harmony within families. There's also a special needs trust is helpful for individuals with disabilities whose management of money is impaired. So let's keep on diving here into special needs trusts. There's essentially three types of trusts. There's a third-party standalone special needs trust. There's a first-party standalone special needs trust. It's also known as a D4A trust. And then there's a pooled trust, and that's called a D4. It's also known as a D4C trust, and that can be a first-party or a third-party trust. So a third-party standalone trust is it's a type of trust. Again, it's standalone. It's on its own. It is an individualized legal document that is created by an attorney, by clients with an attorney, okay? And generally, it's more flexible and tailored to the person who's going to be receiving the funds in the trust. So the beneficiary, the individual with disabilities. There's not a lot of PALMS guidance around third-party special needs trusts. This is a good thing, right? Because there's more flexibility and with providing disbursements or providing funds to for the benefit of the beneficiary. The trustee can be a professional or a non-professional. So what I mean by that is a non-professional trustee is typically somebody who's a family member. It could be a friend, it could be a sibling, it could be an aunt, an uncle. So that's what a non-professional trustee is. A professional trustee is typically going to be a nonprofit organization like Plan. It can also be a bank as well, or a financial institution. It could be an accountant or an attorney. Under third-party standalone trusts, I want to give an example of one. So we have a number of third-party standalone special needs trusts because we have parents who are concerned, but they have an adult child with disabilities or even a minor child with disabilities. And they're concerned that when they become incapacitated or pass away, when the parents become incapacitated or pass away, that the inheritance that would go to their disabled child would impact that child's public benefits. So all of a sudden they have all this money, this inheritance going to an adult or a child with disabilities who's on public benefits, and especially if they're those mean tested benefits, so like Medicaid or SSI, things like that, that could kick them off of their public benefits. So we don't want that to happen. So instead, what parents can do is that they can create a third-party standalone special needs trust, or actually a third-party pool trust, which we'll talk about in a second. And they can do that while they're alive. So they can create the trust now, and then when they pass away, the trust would be funded by the inheritance for their child who with disabilities, who is the beneficiary. So this is really a great tool, right? As a parent, you can create this trust where their inheritance is going to be available for your child to be able to utilize after you've passed away, but it's still going to allow them to be on public benefits. So it's a really great tool again, and you can do this now. And so this is really the biggest takeaway, I think, from the presentation today, is that if you are a parent and you are in this situation where you're concerned about any money going to a child with disabilities or another family member with disabilities, actually, then what you can do is you can create a trust now while you are alive to have those funds go into that trust when you pass away to allow that child, that beneficiary, to still have public benefits and have these funds sitting around out there for them to utilize to pay for all those quality of life things that public benefits do not cover. The other thing to keep in mind about third-party trusts, particularly third-party and third-party standalone, third-party pooled, is that there's no Medicaid payback clause. So what do I mean by a Medicaid payback clause? So Medicaid, under a first-party trust, any first-party trust, Medicaid says that when the beneficiary passes away, any money remaining in the trust must first be utilized to pay back Medicaid for any expenses that they have covered for the beneficiary's lifetime. So if there was a trust that has a first party trust that has $500,000 in it, and let's see, and Susie is the beneficiary, and Susie utilizes those funds during her lifetime. And then when she passes away, let's say there's $50,000 remaining in that first party trust. Medicaid gets to say, we get that $50,000 to pay off any of the expenses that we covered for Susie during her lifetime. They only get up to whatever they covered. So if Medicaid only paid for $25,000 worth of care for Susie during her lifetime, they would only be paid the $25,000. And then the remaining $25,000 of the $50,000 would then go to what's called a remainderman, the people who would get those funds that the creator of the trust, the grantor, has outlined essentially. So, but if Medicaid has a claim for, let's say, $300,000, then all the funds in the trust would go to Medicaid. That $50,000 would essentially go to Medicaid. Nobody else is going to be required to pay off the outstanding amount of $250,000, okay? But the point of this is that the money in a first party trust goes to pay off Medicaid. So this is another advantage of a third party trust, which is there's no Medicaid payback clause. So again, if you do planning in advance and you create a third party trust for an individual with disabilities, for that beneficiary, then you can, again, allow them to receive their public benefits and have these funds available to supplement them during their lifetime. And then if there's any money remaining in that third party trust after they pass away, it's going to go right to the remainderman that you have named, for example. It's not going to have to pay back Medicaid. All right, so those are some big differences between third party and first party. Let's talk a little bit more about first party D4A trusts. A first party D4A trust, it's a standalone trust. It's a legal document that's drafted by an attorney. It has individualized terms. Most importantly, a first party D4A trust can only be created for somebody who's under age 64. So that's really key to know. Let's see what else. Again, the trustee can be a professional or a non-professional, right? So, and this is the other part that makes a first party different from a third party. A first party is being created, the grantor and the beneficiary are one and the same people, right? So let's say this is an individual who was in a car accident and they get a personal injury settlement. At the same time, they are receiving public benefits. So if they got a personal injury settlement of, let's say, $300,000, and they're on public benefits, getting that $300,000 is going to potentially kick them off some of those public benefits. Instead, this person can keep their public benefits and put that personal injury settlement into a D4A trust and allow for those funds to then be available to supplement public benefits without it impacting those benefits. So again, the first party is created by the grantor, who's essentially the same person as the beneficiary. The beneficiary is creating this trust for themselves with funds that they are receiving. Okay. And again, a first party trust does have a Medicaid payback provision. So one of the ways I like to think of or remember this is a first party trust means that Medicaid gets paid back first. All right. So a first party trust requires Medicaid to get paid back first. All right. So let's talk about the third type of trust, and then we'll kind of run through a few scenarios, which I've already talked about a little bit, but I find it helpful. Let me just double check the time. Okay, we're doing all right. So the third type of trust is a pool trust. So how is this different from the two other types I talked about? A pooled trust is not an individualized document that's created by an attorney on your own, essentially. A pooled trust, there's a master trust instrument, and essentially you sign a document, depending on the type of trust, to join that master trust instrument. You can have a first party or a third party pooled trust. So again, to remind you, a first party trust, the grantor, the creator of the trust, is the same person as the beneficiary, the person who's going to be receiving the benefits or the assets, or will benefit from the assets in the trust. A third party, somebody else, is creating the trust and funding the trust for the benefit of the beneficiary. So a pool trust, beyond having a master trust document, the funds are pooled for investment management purposes. So this is really good it's cost effective for small estates and inheritances. And even though the funds are pooled for management purposes, each beneficiary has their own sub-account. So their money stays in the trust for them, okay? Jane Smith has her own trust sub-account. So it says the third party special needs pool trust for the benefit of Jane Smith. That's the name of the sub-account where her funds are held. One of the other things about pooled trusts that's important to keep in mind is they have to be administered by a nonprofit that is serving as a professional trustee. So that's where plan comes in. We're a nonprofit organization, and we serve as professional trustee of special needs trust, particularly pooled trust, but we also do the standalone trusts. Anything else I want to mention there? I think that is it. So let me just kind of go through some scenarios to kind of help you clarify when it's a good idea to do a third-party standalone special needs trust, a first-party D4A standalone special needs trust, or to do a first-party or third-party pooled trust. So we have Jane Doe. Jane Doe is 80 years old, and she is recently had a health scare and is looking at moving into a nursing home, a skilled nursing facility from her house, because of that decline in her health. She's got $15,000 under Medicaid in Massachusetts. If they're going to help pay for your long-term care in a nursing home, you can only have a primary residence and $2,000 to your name as an individual. So Jane has an excess of $13,000, right? So 15,000 minus the 2,000, which she's allowed to hold on to. So what does Jane want to do with these funds? Well, she has permissible spin downs. She can utilize the funds in that way. The other thing that she can do is she can take those $13,000 and put them into a first party special needs pooled trust. So this is a really great tool that's available here in Massachusetts. If you are over 65, and in particular going to be applying for long-term care Medicaid benefits to cover your care in a skilled nursing facility, you can transfer your assets into a first-party special needs pooled trust, get Medicaid, and have those funds available to help you pay for all the things that, again, Medicaid is not going to cover. So there's a good example for Jane Doe in a first-party special needs pooled trust. The second scenario is John Smith. This is going to sound really familiar. So John Smith is 32 years old. He is on public benefits, and he's also getting that personal injury settlement. He has of $800,000. So what should John do? So one thing that might be a really good fit for John is that he could do a first party D4A special needs special needs trust. And the reason this is a good fit for John is because he's under 64 and he has a substantial amount of money coming to him from the personal, from the settlement. So that would be a really good fit for John, is to do a first party standalone or that D4A special needs trust. Let's talk about Mary. And there's actually a couple of scenarios that would be applicable for Mary. So Mary is going to be receiving an inheritance of $50,000. She's on public benefits and she's 54 years old. Before Mary's mom passed away, she created a third-party special needs trust for Mary. So and then made sure that her last will and testament said, when I die, Mary's inheritance goes to the third-party special needs pooled trust for Mary's benefit. So what this will allow Mary to do is to maintain her public benefits, and then that $50,000 is going to be in a third-party special needs pooled trust for Mary's benefit to supplement those public benefits for her lifetime. And then when she passes away, if there's any money remaining in that trust, there's no Medicaid payback clause, and the funds will go to whoever mom said before she died that she wanted those funds to go to, that remainderment. Let's take that scenario and twist it just a little bit. So again, Mary is 54. She's going to get this $50,000 from mom's estate. Mom did not do any advanced planning. That $50,000 is going to go to Mary individually or directly, that inheritance. What Mary can do is that she actually has the ability to create a first party special needs pooled trust for herself and put that $50,000 in it. So again, Mary still has the power to create a first party special needs trust, pooled trust for herself, which would allow her to receive her inheritance, and that trust would hold the inheritance, and then funds would come out of that trust for Mary's benefit, while allowing her to maintain her public benefits. Keep in mind that when Mary passes away, if there's any funds remaining in that first party special needs pooled trust, Medicaid gets paid back first from those funds. So hopefully those scenarios really helped kind of highlight what type of trust would be a good fit. Let's kind of revisit that with a few other scenarios in general. So again, a third party special needs trust can be funded by life insurance proceeds, inheritances, inherited IRAs. First party special needs trust can be funded by settlements, unexpected inheritances, right, Mary, or personal injury settlements, so John. So a few other things to consider when you're establishing a special needs trust. Besides what type of trust best suits your situation, you also want to think about what type of trustee do you prefer. So we already went through this concept of professional versus non-professional trustee. And so there's a little bit more consideration to be had there, which we'll talk about in a second, in particular with connection to administration of the trust. So you also want to think about how you want the funds to be managed. Do you want them to be professionally managed, or would you be comfortable with them being managed by somebody who maybe does not have the background in managing assets to do that appropriately? So some of the things that a special needs trustee is responsible for is making sure that the trust is used for the sole benefit of the beneficiary. Typically, they're also doing things like paying taxes. There's income taxes, tax returns that have to be prepared. You're also doing expenses or that are also being paid. There's also regular disbursements. And what I mean by disbursements, it's distributions out of the funds held in the trust for the benefit of the beneficiary, typically to a third party, whether that's reimbursing a friend or paying a vendor directly. They're also managing the investment of the trust funds, reporting to government agencies about the existence of the trust, also making sure that they understand the public benefits rules to make sure that the beneficiary maintains their benefits, public benefits, right? So if the trustee makes a disbursement for the benefit of the beneficiary and that endangers that person's public benefits, kind of defeats the purpose of the trust. So that's why it's very important to know the public benefits and the rules associated with that, and then what would then allow for disbursements or not to take place for the benefit of the beneficiary. Also, the trustee is making sure that they're maintaining regular contact with the beneficiary, family members, friends, other members of the support team for the beneficiary. And the trustee has a fiduciary obligation or a duty to be doing all of these things. Some other things to think about when you are contemplating who should serve as trustee in connection with trust administration is again, does that person have the knowledge and the skill regarding special needs trust in relation to the public benefits that the beneficiary is receiving? Will the trustee be able to serve for their lifetime? Do they have health issues of their own that might prevent them from being able to fulfill their fiduciary obligations? Do you have somebody named as the backup or successor trustee that will be able to step into the shoes of the primary trustee of the special needs trust to serve? Will serving as trustee damage family relationships? So one of the things that we get a number of calls about is that we have families that have set up third-party, standalone special needs trusts for children with disabilities. Parents have passed away. They named siblings or uncle or aunt. And unfortunately, that what happens is that throwing money into the mix in that management of the funds really damages or causes conflict between the beneficiary and the family member who's serving as trustee. So there's a real impact to family harmony and relationships when sometimes you have a family member who's serving as trustee and has to say, no, if I give you that, if I pay for that for you, it could jeopardize your public benefit, so I can't do that for you. So that's something to really keep in mind. Is family harmony important to you? And could putting somebody who's a family member in the position of trustee going to impact that relationship between the family member trustee and the beneficiary? You also want to make sure that there's a timely processing of disbursements and the accountings, which is basically documentation of all the income, the expenses, and the disbursements made on an annual basis. And then also making sure that final tax returns, not just annual tax returns, but final accountings and tax returns are done. And if it's a first party D4A trust in particular, that there's a communication with Medicaid, right? Because we have to, because it's a first party, we have to pay off, communicate and pay off with Medicaid any claim that they may have if it's a first party special needs trust. So also the trustee is contemplating, keeping in mind, what can be paid for the benefit of the beneficiary that would enhance their quality of life. So one of the things to keep in mind is that a pooled trust does allow for ongoing reduced costs compared to traditional trusts, like the standalones, which is what I was talking about a little bit earlier. Using a professional trustee-like plan does allow for some of these, does kind of address some of these concerns, right? It addresses having a trustee who has a knowledge of public benefits and making sure that any disbursements won't affect those public benefits. It maintains family harmony because now there's not that conflict over whether or not why the family member trustee is not dispersing the funds when the beneficiary has requested them. And it's also making sure that things are being done timely because that is what we do on a regular basis. Okay, so again, families who do not want to place that weight of serving as trustee on a family member, that responsibility of administering the trust, that's when having a professional trustee such as plan makes sense. If you want to make sure that things like inheritances, legal settlements, life insurance are going to a special needs trust so that public benefits aren't interrupted. And then also if there's smaller assets and you're looking at somebody's over 65, again, keep in mind they're applying for Medicaid benefits. You can always do a first party special needs pooled trust. So those are some examples again. How do you go about establishing a special needs trust with plan? So you would complete an application. You can find that online. We have a really robust website, and I'd invite you to go check it out. You can complete it online, and then what would happen is when the trust is created, and then it is funded, right? Those are two separate things. They can happen at the same time, or they can happen at different times. Then once the trust is not only created, but then also funded, then a service coordinator, that licensed social worker, will be reaching out to the beneficiary and support team to develop a spending plan to meet the needs and wants of the beneficiary. Excuse me. Plan has a trust department that then is going to work with the service coordinator to address any disbursements and make sure the disbursements are not going to impact public benefits. Funds are invested with Webster Private Bank. And again, we do not have any minimums for our pool trusts. We typically recommend at least $10,000 because that gives us some funds to invest. A little bit more detail. Beneficiaries, again, are assigned that dedicated service coordinator, the licensed social worker. Disbursements are reviewed typically and paid out, or there's some sort of response every 7 to 10 days of receiving a complete documentation regarding that disbursement. Tax forms are prepared and typically forwarded. Again, Webster Bank is doing the management of the investment of funds for plan. And again, we can work with any age, disability, or amount. There's no minimum for pooled trusts, but we do, again, recommend that $10,000. Social workers, so they are our service coordinators are, again, the licensed social workers. They're providing support and guidance on how to use the trust funds in collaboration with the beneficiary's public benefits. And our service coordinators are wonderful. They are experienced with all types of disabilities and ages. They also are easily accessible. So our service coordinators really meet the beneficiaries in the best place where they're comfortable and safe. So we've had service coordinators who meet in public spaces like libraries or McDonald's. We've had service coordinators go to skilled nursing facilities or go to a beneficiary's home. We also have service coordinators who regularly telephone call or remote meeting. So it really depends on what's the best communication method for the beneficiary. Our service coordinators also are very knowledgeable about family dynamics and really provide an individualized approach to our beneficiary needs and can suggest additional resources that are out there that might be very specific to the beneficiary and their situation. Trust funds can be used to supplement respite care if it's not covered by insurance. And then also the funds in a special needs trust can be used to supplement companion services or personal care attendant services. So that's really helpful to know as well. All right. So time-wise, I think we're doing okay. I want to spend a little bit of time talking about ABLE accounts because ABLE accounts are, like I mentioned earlier, this great tool that is such a good companion to special needs trusts. So ABLE accounts came around, like I said, about a decade ago, a little over a decade ago. And you can have an individual with disabilities can have one ABLE account, and they can have, at least in connection with SSI benefits, if that beneficiary is going to or is receiving SSI, they can have a max of $100,000 in that account. Typically, they are the beneficiary must have been deemed or had the disability onset had to have occurred now before age 46 as of January 1st of 2026. Before that, it was only up to age 26. So it's great that now it's up to age 46. On top of that, there's also a certain amount of money that can go into an ABLE account on an annual basis. So typically in the past, it's been tied to the annual gift tax exclusion amount. So for right now, it's $19,000 can be gifted into the trust. I'm sorry, into the ABLE account from the trust, for example. And we've done that before when somebody, let's say, wants to have a little bit more flexibility and freedom with the funds to go purchase a car, to help pay for things in connection with shelter. So again, the ABLE account is this great companion or tool that can be utilized in collaboration with a special needs trust. To circle back, so like I said, the annual gift tax exclusion amount that was tied, that's what it was tied to in the past. This year, there's actually, you can give up to $20,000 to an ABLE account. The beneficiary, the individual with disabilities, can also have income from work flow into the ABLE account in addition to any sort of gift up to that annual amount from other sources. There are these qualified disability expenses. So that's what makes ABLE a little bit different from the trust. It has very defined examples of what the funds can be used for. There's a bit more flexibility and freedom, like I mentioned earlier, with ABLE accounts on what they can pay for versus what the special needs trust can pay for because of the PALMS regulations. There are Medicaid payback clauses for all ABLE accounts. And it's also helpful to know that there's tax fee free growth if in the ABLE accounts, if the funds are used for qualified disability expenses. Let's see. I think that's all I wanted to mention with regards to the ABLE accounts. So that's really about it here. So in conclusion, doing that special needs trust is a really great planning tool, right? So main takeaways. If you are the parent or a family member of an individual with disabilities and you want to do planning in advance, you can do a third-party trust, a third-party special needs trust, whether it's a pooled trust or a standalone trust. And that would allow the individual with disabilities, the beneficiary that you create the trust for, to receive an inheritance while still allow them to maintain their public benefits. you can do that planning in advance, and there's advantages to doing that, including no sort of Medicaid payback clause, and a little bit more flexibility because it's a third-party special needs trust. A special needs trust will also allow for that enhanced quality of life while the individual, the beneficiary, is maintaining their public benefits. And then again, if you do a third party, you can, and even a first, but really a third, because there's no Medicaid payback clause, the funds that remain at the death of the beneficiary can always flow to whoever you name as the remainderman, the beneficiaries after the sole beneficiary dies. Okay, so including to a nonprofit. So it can go to a charity, it can go to other family members, but you have that flexibility to name that if you do a third-party special needs trust. I think that's all I want to mention. I'm happy to take questions now if folks have them. So I'm just gonna leave this up and then we can address, actually, maybe I'm gonna end them. Let's see. I'm gonna stop sharing here. I think somewhere. I'm gonna stop sharing so that we are, there we go. So we can just have a conversation here. There we go. Okay, wonderful. So let me check out the questions. So I have a question that says how to advocate for not transitional housing rules and outdoor smoking for all. I'm sorry, I think that it has 10:30 meeting, but I plan to be back this afternoon. Thanks for this good advocacy. You're very welcome. So I think that's a little bit outside of my wheelhouse. So I would say that might be a more specific question for transitional housing. Let me double check the Q&A. Okay. Are there limits to the sizes of any of these trusts or expenses or costs to manage the trust fees? Thank you. Yeah. So, as I mentioned earlier, with pool trusts, we typically recommend that you have at minimum $10,000 because that gives us funds to be able to invest and build upon. There is not a limit with regards to, there's not a ceiling. So we have trusts that have pool trusts that have multi-millions in them. So we're happy to take those on, absolutely. For our standalone trust, so if we were to manage or to administer a third-party standalone special needs trust or a first-party D4A special needs trust, we typically do request that there's a minimum of $750,000 in liquid assets. So that's, again, only for the standalones, not for the pool trusts. And then again, there's not a ceiling with regards to how much money can be in those standalone trusts. We have standalone trusts of which we are the professional trustee with, again, multi-millions in it. Expenses or costs to manage the trust. So it depends on the type of trust that is being managed. But I can give you some general fees. So there are enrollment fees. You'll see that outlined on our website. And it really just depends on who is doing the application, who's going to be signing the documents. If it's a third-party trust, typically the enrollment fee is around $500. If it's a first party, it can range from $600 up to, I think, $750, depending on who's going to be completing the documentation. With regards to annual fees, we have a 2% annual fee on anything $1 million or under. If there's over $1 million, we do not have any additional fees on that amount. So it's a 2%. And then that's just for our trustee services. And then there's an investment management fee on an annual basis, and that is 75 basis points or 0.75%, and that's on the entire amount that is managed. On top of that, we do have, usually it's a few $100s to do the tax returns on an annual basis, because those are important. And then there are closing fees. So, and just as a general idea, we usually say around $2,000 for closing fees, and that's when the trust is ending because there's insufficient funds or the beneficiary has passed away. And those expenses or those fees cover dealing with Medicaid, right? Doing the Medicaid payback claim, having funds go out to any remainderment if there are any, the final trust tax returns, and the final accounting. I think that covers everything. Let's see. If I have already set up a trust, can I set up a special needs trust to be added to the original trust? So that's a great question. So that's where I would say it depends. You would want to work with your estate planning attorney, your special needs, estate planning, elder law attorney, and take a look at the trust that you currently have in place. And then you can determine whether you want to do a standalone special needs trust, or you can also simply create a pool trust, a third-party pool trust with plan, and then have it referenced in your documents. So there's a few different options there, but really it's going to be going back to the attorney who initially worked with you, or another attorney, estate planning attorney, with regards to your current trust, and then figuring out what's going to be the best option for you. Standalone special needs trust or pool trust based on your specific situation. And you're more than welcome to reach out to us. I work with several attorneys to help streamline situations as well. So your attorney can also reach out to me too with any questions. Happy to answer them. Another question says, did you say that an ABLE account has to be court ordered? No, an ABLE account does not have to be court ordered. It can be, but it does not have to be. Anybody, you can go set up an ABLE account without a court order. People can set one up for you without a court order. All right. I think those are all of the questions. And Sophia, thank you so much for putting the plan website out there. Again, you're more than welcome to reach out to us. We're always happy to answer questions. And then, oh, there's another question. Hold on. Great. Let me answer those two really quickly. So a range of costs for setting up a trust. So with regards to doing a trust with plan, there is an enrollment fee, depends on the type of trust. It can range anywhere from $500 to I think $750. That's the enrollment fee. If you're going to work with an estate planning attorney to create a trust as part of your estate planning, a standalone or otherwise, then it's going to be whatever the estate planning or elder law special needs attorney typically charges for their services in doing that. And I'm sorry, I thought I saw another question here, but I don't know where it went. Okay. It looks like that was it. There was a question and then it seemed to disappear. Oh, there we go. What is the beneficiary? Oh, what if the beneficiary is no longer on SSI when the estate is dispersed? Is there a payback rule? So that's a good question. I think so. Not necessarily. I'm not sure about SSI. I don't think it is necessarily for SSI, but for Medicaid. So if somebody has utilized Medicaid during their lifetime in any state, then typically there is going to have to be payback. So for example, if there's a first party special needs trust, so that's important to know, right? What type of trust is there? What kind of benefits is going to help you figure out if there's going to be a payback? So we've had situations where there are beneficiaries who have moved between states and they were on Medicaid in state 1 and they were on Medicaid in state 2. And so we actually have to notify and pay back any Medicaid claims in both states. See if there's any other questions here. I think that is it. Any more out there for me? Yeah, okay. So I think that's all I see. Okay. And otherwise, oh, yes, yes, please. What was the additional question? I'm afraid I don't see it. Yeah.
I responded to that question,
Oh,
George.
great.
It should have come through so you can see it in the question and answer, and I will also put it in the chat as well.
Oh, wonderful. Thank you so much. I appreciate that. Okay, well, I think that does it. Again, thank you all so much for your time today. I hope that gave you some food for thought. And if you have any additional questions, please feel free to reach out to us here at Plan, and we'd be happy to answer them for you. Thank you very much.